Okay, on the record, in the matter of Hamilton Road LTD versus Claude Miller, file number is 23-01344. You have to be quiet. We're in the record. Counsel appearance, please.
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road Limited.
Good afternoon, John was here on the defendants, which are the occupants of the property.
You come up to the table. Okay, who's in the courtroom?
Yeah, Betty Miller.
Betty Miller, okay. And Ms. Miller, your attorney is Mr. Fair?
Mm-hmm.
Is that a yes?
Yes.
Okay, and who is the gentleman with you?
A friend of mine.
Oh, okay, sounds
I live in the home.
Yeah.
Daryl Davis.
okay, sounds good. Okay, so they say was a date set for a continuation of a motion for escrow. I believe there was another motion, but I don't. There was a motion for order for escrow. Was there a motion to lift stay as well?
Yes, Your Honor.
Okay. Okay, and I requested for you to have your clients appear, largely because I had heard multiple times from plaintiff's counsel or express a concern that you were not representing anyone that was connected to this actual property. If I am categorizing the concern correctly, Mr. Turnwell, if not, please correct me.
You are. My office received a phone call from Ms. Miller saying she hadn't signed certain documents and didn't understand what was going on. Just recently from the Court of Appeals, my office again has received a deficiency notice from the Court of Appeals saying Ms. Miller hasn't signed those documents as well.
Okay. What are those documents? Are they engagement documents or
the actual appeal itself?
Oh, okay.
And the case will be dismissed now unless she signs it.
Mr. Fair, are you working with your client to get that taken care of, or?
Well, the short answer to your question is yes, Your Honor. And that's not my understanding of the Michigan Court of Appeals concerns. But having said that, whatever the concerns are, we're within the 21 days and they will be taken care of within the 21 days. And the case is still pending before the Michigan Court of Appeals.
Okay. Okay. So addressing the motion to lift the stay, it sounds like this matter is still pending before another court. Accurate, or am I incorrect?
That's correct, Your Honor.
Your Honor, there's a big jump the defendants have made and ignored. The case has been dismissed in the circuit court, the trial court. To get a stay now requires an order from the trial court, which is the circuit court, which they have not applied for, and or post a bond. Initially, they're required to post a bond in the Court of Appeals and get an order staying these district court proceedings. They have not done either. We're asking for possession only. This is no determination of ownership. If they want to proceed with this Court of Appeals case when they never even showed up to argue the trial court case, have at it. But it's my position, it's my client's position. This is entirely about delay. And I see Ms. Miller in a courtroom here today, but in the Court of Appeals case, in the circuit court case, she lists her address as somewhere different, that she's not an occupant. In fact, on those pleadings, she lists her address as on So she's not even an occupant of the address. Yet we were asking the court to stay the proceedings of a place she's not occupying. And we're asking for possession only. There's no circuit court order. There's no court of appeals order. The circuit court case has been determined and summarily dismissed.
Who's possessing this property, Miss Miller?
It was my husband, but they've been staying in it. I can't afford to rent it.
You're not possessing the property?
Yeah, I want to take the property.
No, that's not what I asked you. Do you live in the property?
No,
Okay. Who is they? You said they are staying in it. Who's they?
Me and my wife live in the property, Your Honor. Daryl Davis and Mary Davis.
Daryl Davis and Mary Davis. Who do you pay rent to, Mr. Davis?
Well, we were paying rent to Claude Miller, and he passed, and then they were trying to refinance the house or to sell the home. From my understanding, I did about $10,000 worth of work, so we offset that. After I didn't know he repossessed it, put a new fence and everything in at the time, even after, so that was how I was paying rent.
Okay, sounds good. And Mr. Fair, you represent Miss Miller exclusively, though, correct?
No, I represent the occupants at that property, Your Honor. All occupants at that property. And the owner of the property is Miss Miller and her deceased husband. And they're
your device is breaking up. I don't know if
it is?
Yes.
Oh, okay, I'm sorry. Let me just go to Plan B real quick. Is that any better? If you just give me a moment, Judge, I can come in on a different device.
Okay, yes, please do.
Okay.
Sir. Yes.
It would be helpful, Judge, if I had the Zoom information. I'm looking it up now, but if the court could give that to me, I could come in. Otherwise, I'm still trying to pull up the Zoom information. I should have it.
Could you give them the Zoom number, please? The other device.
Yeah.
Okay.
All right.
Okay. Can you repeat your statements?
Well, Your Honor, I'm representing the occupants at the subject property, and those occupants are Daryl Davis and his wife. The owners of the property are Betty Miller and her deceased husband, which is subject to the litigation in the Michigan Court of Appeals. So there's no question that the property is being occupied, that the plaintiff is attempting to evict the occupants, and I'm representing the occupants.
Okay, so you're not representing, so then I'm confused. You're representing Miss Miller in a separate case and then the occupants in this eviction?
No, Judge, I'm representing Betty Miller in this case. Her husband has passed away, and the other occupants in this house, which is Daryl Davis and Daryl Davis's wife. They are occupants of the house.
Miss Miller is not an occupant of this house.
Well, that's what she has represented to the court. but I am representing Daryl Davis, who is an occupant of the property.
Your
And
Honor,
that the plaintiff is attempting to evict.
if I may.
Mr. Turnwell, yes.
At the last hearing, Mr. Fair represented that he was representing Matthew Brown Jr. II. And Ms. Miller is not the owner of the property. Hamilton Road Limited is, by virtue of a sheriff's sale on September 29th of 2022. Ms. Miller just said she is not an occupant. You know, all along he keeps saying he represents the occupants, and now we get different names for different occupants at different motions and different hearings.
I tend to agree. This has been very confusing, and I don't know how Ms. Miller becomes even interested party in this if she's not living in this property. And I think you knew that because that's not the address that's on this Court of Appeals filing, which was attached. It was the address of which she lives. The tenants that live here don't have any standing in the action that would have been before the circuit court. And then this is subject to a sheriff's sale. So why would they not be evicted? Did the sheriff's, you're attacking the legitimacy of the sheriff's sale in the other case?
Yeah, well, absolutely, Judge. And if we can just back up, number one, I never said that Matthew Brown was an occupant of the subject property. Matthew Brown is an individual who was working with Betty Miller in order to redeem the subject property. But having said that, and I don't want to, I guess I don't want to repeat myself, but maybe I need to, is the cause of action is against the occupant, and Betty Miller still owns a ownership of the property, in that issue of ownership has not been decided by the Michigan Court of Appeals. Now, Judge, I think it's important to note in this particular case that the plaintiff never had a landlord-tenant relationship with Betty Miller, never had one. It was a mortgage company that had the relationship with Betty Miller. And at the sheriff's sale, the plaintiff purchased the property at the sheriff's sale. That's fine. So what happened in the interim? In the interim, between the time of the sheriff's sale and the time that the redemption period was up, the plaintiffs in the circuit court case, which is Betty Miller, the estate of Claude Miller, Matthew Brown, and Innovative Property, were attempting to redeem the subject property. That's what they were attempting to do. And they were attempting to redeem it from the plaintiff. And
I recognize that. But my concern is that Betty Miller is not a party in this eviction because she does not reside in this property. This eviction is Hamilton Road Ltd. and all occupants, including Claude Miller. She's represented to this court. She doesn't live in this property. I think you knew that. And then you also knew that there were tenants in there that live in this property.
Well, Judge, I can only tell you what my understanding was, and I don't think it makes a difference with regards to this litigation, because the plaintiff is attempting to evict the occupants, and she, Betty Miller, is still an owner, and that issue is being litigated in the Michigan Court of Appeals. So it's not like she's not an owner. That issue is being litigated. And the most important point is, if they're successful in the Michigan Court of Appeals, Betty Miller has complete ownership of the subject property. Right now, ownership is contested. And until it is resolved by a quiet title action, which is the whole point, a quiet title action, it's got to be quieted. It is still an open question as to who owns it.
I recognize that. The concern that I have is that she doesn't live in this property. She is trying to attack the validity of a foreclosure sale in efforts to redeem the property. I don't even see where I have a viable case pending in another jurisdiction. I don't see that.
Well, what you see though, Judge, is that if the plaintiff is trying to go forward with an eviction, it presupposes that number one, he owns the property, and number two, that the ownership of the property is not contested. And as it stands right now, it is contested. It's not uncontested. It's
What
not
information or documents did you provide to court to show me that there is a contested action pending in court? Because I only see what Mr. Turnwald sent me.
Well, we have. Well, I guess first question is there a question as to whether or not the ownership of this property is currently before the Michigan Court of Appeals?
Your Honor.
There is absolutely no issue. But having said that, what we did do is...
Is that a question for Mr. Turnwald?
Okay, yes. Ask
Mr. Turnwald can respond to it.
There's a simple answer here, and it is MCR 7.108 subsection B. An appeal does not stay execution unless the appellate files a bond or the trial court grants a stay. Trial court is the circuit court. Hasn't granted a stay. They haven't even asked. No motion's been filed. The appellate court, no bond has been issued. No stay has been granted. There is nothing staying these proceedings. It's not disputed Hamilton Road purchased this property at a sheriff's sale almost a year ago. 6 months redemption period expired March 29th. It was a frivolous trial court claim being made. No one even showed up to oppose it. They only filed an answer after the hearing was already concluded. It's an entirely frivolous appeal. No attorney has signed the appeal. No attorney has signed the trial court motion. This has all been about delay. Delay.
Mr. Fair, has there been a bond posted?
In the well, there's been no bond in the district court, and there's
that's not what we were referencing. He was talking about for your Court of Appeals in order to get a stay. Did you request a stay from the? Did you request a stay from the trial court?
No, Judge, he's conflating the law here. Okay, he's completely conflating the law. Number one, you can't request a stay in the circuit court or the Michigan Court of Appeals unless a stay has been denied in the district court. He's conflating the law. So that's number one. Number two, really, quite frankly, the circuit court with regards to possession doesn't have anything to do with the district court. And then number three, Judge, you never answered your question. Your question was, is there a pending Michigan Court of Appeals case with regards to the ownership of the property? I answered that question, yes. He's got to answer that question, yes, also. But I've also attached to our answer a copy of the documents that shows that I never interrupt you. Please don't interrupt me. I have attached to our answer the copy of the filing in the Michigan Court of Appeals. But Judge, once again, he hasn't answered a question is whether or not the case of quiet title with this property is pending in the Michigan Court of Appeals. That's really a yes or no question.
There is a case in the Court of Appeals pending. However, you have ignored the court rules. Here's another one for you. MCR 2.709. Now, this is plain English. Please answer it. Accepted the automatic stay, which doesn't apply here. An appeal does not stay the effect or enforcement of a judgment.
Judge.
We have a judgment in the circuit court. There's no appeal that stays that unless you ask for one in the trial court or in the Court of Appeals. You haven't, because they ain't gonna be granted. This is just about delay.
Yeah. Judge, he's conflating the court rules. What he is making.
Read the court rules.
Okay, we're not going to talk over each other.
Yeah. What he is making reference to has absolutely, positively nothing to do with the district court. It is just.
It is the Court of Appeals.
No, Judge, he keeps interrupting me. I will not interrupt him.
I agree, Mr. Turnwald.
And this is the second time he's done it, if not the third. So with regards to what he's making reference to, it's only with regards to a circuit court case and ownership and possession. That was never before the circuit court. What was before the circuit court was quiet title, not possession. Quiet title. And so there is, and they have filed their appeal with the Michigan Court of Appeals that has nothing to do with the district court. What's before the district court is their issue of possession. And our position is real simple. This case should be stayed pending the outcome of the Michigan Court of Appeals. And why is that? Well, Judge, it's real simple. We don't want to have inconsistent determinations with regards to this property. So in other words, if the court says, well, Mr. Plaintiff, you should get possession, and the Michigan Court of Appeals says, no, you should not get, no, the ownership goes to Betty Miller, then it's inconsistent results by two different courts. So it's real clear this case should be stayed pending the outcome of the Michigan Court of Appeals that is current before the court. And not to conflate the circuit court with the district court. They haven't got anything to do with each other. One is quiet title and the other is possession.
May I address this?
You may.
It's completely misrepresentation of the law, facts, and reality. We're asking for possession only. Possession will have nothing to do with ownership. Possession was stayed pending the outcome of a circuit court case, which their complaint was denied. And it's not even the same parties. Today, for the first time, we've learned there's tenants occupying possession here that have possession of the premises. That was completely misrepresented by Mr. Fair last time. He said Matthew Brown Jr. II was an occupant. Obviously, he's not. We're only asking for a writ for possession. What is the use of having a trial court when the trial court enters a judgment in your favor and the district court ignores that judgment? If he wants to stay the proceedings, he needs an order from the trial court, MCR 2.109A. The court rules are quite clear. They also need to post a bond in the Court of Appeals. None of that has been done. And that's just to stay actions from the district court. We're talking about tenants occupying a premises. We're not talking about ownership. And frankly, if you want to take the opposite side, Hamilton Road Limited would be happy to take possession of the premises and then post a monthly bond pending the outcome of a frivolous appellate court proceeding.
Yeah, now we're starting to go in circles here, and we're repeating ourselves with regards to issues that have been refuted. And I don't want to keep, refuting.
I don't want to keep going back and forth either. Yeah. I do think Mr. Turnwell is conflating as it relates to this eviction. We are the trial court on this eviction. The circuit court has nothing to do with this. The circuit court only has to do with the quiet title possession issue.
Quiet title ownership, Your Honor.
I recognize that that's not what this is. So they would not need to go to the circuit court to get a stay. They would need to come to this court to get a stay if that's what they want to do.
Yeah, and that's what we've asked for, Judge. We asked for a stay pending the outcome of the Michigan Court of Appeals case, because if they rule in we rule in our favor, and I'll say our favor, then the defendants are entitled to possession. And what the plaintiff wants to do is divest them of possession when the issue of ownership is still in question. It just doesn't really make a lot of sense.
Mr. Fair, your appearance specifically named that you represented who?
My appearance, I'd have to look at the appearance, but my appearance says Claude Miller and all occupants. And we called it Claude Miller because that is and I have to go back and look at the complaint.
Well, I want to know who engaged you, because I do agree with Mr. Turnwell as it relates to the names that you knew who lived in this property when you appeared in our court, and you know who you represent, and you also know that Ms. Miller did not reside in this property. So this is an eviction for possession. She really doesn't have a standing as it relates to this case if we proceed for possession.
All right, Judge, so I can make the record clear. Okay. Number one, I was advising Renovative Property and Matthew Brown, Betty Miller, and the state of Claude Miller. I was advising them during this redemption period. And once the redemption period passed and the plaintiff refused to allow the defendants to redeem the subject property, then it degraded into this district court case. And so I was representing whoever the plaintiff was suing in the district court case. Now, clearly, that does not include Innovative Property. Clearly, it doesn't include Matthew Brown. But with regards to Betty Miller and the state of Claude Brown and Daryl Davis, well, Daryl Davis and his wife live there. But the owners is Betty Miller, based upon the pleadings that were filed in the circuit court. So you can't say that, well, you're not in the property, but you own the property, and therefore you don't have standing on the property that you own. It's before the Michigan Court of Appeals judge. I mean, it's just
until the Michigan Court of Appeals, because right now your claim in the circuit court was denied, and until otherwise, she's not the owner. Right now, the owner is the plaintiff on this file, which is Hamilton Road.
No, Judge, it's contested. It's contested. You can't. You can't get.
And it sounds like your Court of Appeals case is on the verge of being dismissed too.
Well, no, Judge. No, I do this. I do this type of litigation all the time. It's not on the verge of being dismissed. They sent a deficiency letter. They send deficiency letters all the time, telling you what you need to do to correct your appeal.
I recognize that.
Yeah. So it's not like the case is dismissed. And let's assume that's the case.
I didn't say that the Court of Appeals case was dismissed. So on the verge, you don't correct the deficiency, what's going to happen, Mr. Fair?
Well, if you don't correct the deficiency, it will be dismissed. It will be dismissed.
That's what I said. That's what I said.
Yeah, and Judge, and that's all I'm saying. It's not. Does not affect whether or not the case is still pending. It doesn't affect whether or not there's still an issue of ownership. It doesn't affect that the Michigan Court of Appeals can, at the end of the day, rule that Betty Miller is still the owner of the subject property. And Judge, this is not like Betty Miller didn't pay the mortgage company and that they're suing for eviction. We're talking about an individual who purchased it, and the allegations are he would not allow them to redeem it. And Judge, why wouldn't he allow them to redeem it? Because the redeeming is the redemption price, and he wants to sell the property at a windfall. He's not going to live there. He wants a windfall because of the value of the property. So, when you start talking about equities, he's got unclean hands, Judge.
Okay.
I mean, just no question about it. Judge.
Thank you. Thank you, Mr. Fair. I've heard enough for today. I wanted to make sure you guys got as much out as possible. But nonetheless, I believe that the case needs to be stayed pending the ruling from the Court of Appeals. However, I am going to grant the motion for escrow as requested by Mr. Turnwell. There's no reason why anyone should live rent free, and they're going to escrow it with the court.
Judge, may I address the issue of escrow? Well, I'm still talking. Judge, the court rules say that there should be escrow. I agree that there should be escrow. The question is, how much should escrow be? And what I would like to put forth to the court is what they're requesting is $2,000. The $2,000 presupposes that they're the landlord and my clients are the tenants, and the landlord wants the lease agreement to continue at that price. That's number one. We don't have a landlord-tenant situation here. Number two, and I've attached to our brief, is that the mortgage payments by Ms. Miller was a little over $900 a month. That's it. And that is...
Mr. Fair, what do you mean we don't have a landlord-tenant situation? They were renting from Mr. Claude Miller.
No. Wait. The landlord, there's no landlord-tenant relationship between the defendants and the plaintiff.
I recognize that. But if what you're saying is correct, and that is that Mr. Miller owned the property, that I asked Mr. Davis, who did he pay his rent to? He said Claude Miller. And so I received the motion requesting a fair market value, which I think is fair, $2,000 a month for the rent. And you want us to have them escrow the mortgage amount because the people who have indicated on this record that they live in this property were not the owners. They weren't paying the mortgage.
Well, Judge,
these people didn't have them living there for the at the price of the mortgage.
Okay, Judge, and that's fine. So I think we should ask Mr. Davis, how much is he paying rent to Betty Miller?
Doesn't sound like he's been paying anything because I asked him.
Well, then I don't know if that's Judge. If that's the case, that's the case. But is he responding?
I can. You want me to respond?
I already asked him how much he paid. He said he didn't pay, and he hasn't been paying anything. He already told us that.
Okay, well, then,
I was paying about $1,000 a month before that, and then Turnwald had sent me a paperwork asking for $1,600 in July to re-sign the lease with him. I didn't at the time who owned the property, and then a month later he asked me to do $2,000. So that was in the paperwork. He sent me paperwork for $1,600, and a month later asked for $2,000.
And Judge, I think that sort of sums it up right there, because Betty Miller was paying a little under $1,000 and he was paying $1,000 and stopped because of the notice he was getting from the plaintiff. And so
okay, let me question Mr. Davis. Mr. Davis, you were paying $1,000 a month to whom?
I've been there for 12 years, to Claude Miller.
To Claude Miller, and how are you making your payments?
Sometimes cash, sometimes would call the mortgage company and directly make them, sometimes to one of their other children. But I've been there for 12 years, Your Honor.
For 12 years, you paid $1,000 and the rent didn't go up or down?
No.
And you called and paid $1,000 directly to the mortgage company? Sometimes,
yes. They gave me the access to pay that too. To MB Financial, and then it was sold to Fifth Third. I made payments to both places.
Okay. Mr. Fair?
Well, Judge, it just underscores the point I'm making. It should be no more than $1,000. But Judge, my argument is should be nominal. And let me tell you why. Because there's no relationship between the plaintiff and the defendant other than the plaintiff purchased the property at the sheriff's sale. And he purchased it at the sheriff's sale amount, which was greatly reduced. And if you look at the interest rate for that amount of money, it would be nominal based upon how much a mortgage payment would be on the amount of money that he paid at the sheriff's sale. But I think the other point is the most important, Judge, is that he's not going to get the money. The money goes into escrow, and the court at some time in the future will decide what happens to the escrow amount. But Judge, if he gets his property, he gets a windfall, an absolute enormous windfall. He's protected. He doesn't need any money in escrow. If he gets his property and sells it.
Somehow you got muted. I'm not sure what happened. Did you mute yourself? Mr. Fair,
I did not mute him. I know
you did it. Mr. Fair, you're muted, so we can't hear anything you're saying.
I think it should be a month.
You think it should be what?
$250 a month. And the reason
Escrow in the amount of $1,000 per month to be paid to the court.
Your
What day
Honor,
of the
I
month
don't
did
get a
you?
chance to address that.
No, I'm done. How much? What day of the month did you pay your rent?
Oh, 15.
Okay, first payment, will be due the 15th of the month of October. You need to make that payment again to escrow to the court, okay? And the court will make a decision as to where that money will go at the conclusion of this case, or once there's a decision made at the Court of Appeals. And assuming, Mr. Fair, that your parties are successful, then this is not an issue. The money will go back to your clients. If not, we'll address that at that time. And Mr. Turnwell, did you already give me an order? I think it said 2,000 on it, though.
Your Honor, I'm not allowed to address the issue of escrow amount.
But you've already did. You gave a motion and you requested $2,000. You all have gone back and forth for over 30 minutes.
Mr. Fair doing the talking, Your Honor.
Well, not all the time. Not all the time. Then there was several times where you talked over him too. So then you go, then he wants to go, then that's completely, it's completely fine if you want to say something else, but then he's going to want to say something else.
Absolutely, Judge.
So when does it come to an end? And whatever you say is not going to change my decision.
Well, that part I understand. That part I believe.
Okay.
The rest of it, no, it's just rent is based upon value. The parties, the tenants, the estate of Claude Miller are unjustly enriching themselves. Had Hamilton Road acquired possession, Hamilton Road would be renting it out either at $1,600 or $2,000 a month. Hamilton Road is being denied that opportunity. I'll address that in a new complaint. I'm not walking away from it. We'll do it.
Well,
Okay.
Judge, you got to do it. We'll see you in court on that issue.
Sounds like you will. Okay. Any additional matters for the record?
Thank you.
Judge, I do want to put one thing else on the record. Counsel keeps saying that this lawsuit and appeal is frivolous. Well, it's not frivolous. What he's saying is unwarranted. And if you look at the court order from the circuit court, it does not say anything about frivolous. And when you add the facts of this case, where the plaintiff was the one who wouldn't allow the defendants to redeem.
Okay.
Everything he said.
Okay. Thank you. Thank you. I got to move on. We got other people waiting for their turn. Thank you.
Thanks, Your Honor.
Bye.